Committee on Industry, Science, and Technology. Today's meeting is taking place in a hybrid format pursuant to the House Order of September 23rd, 2020. The proceedings will be made available via the House of Commons website. So you are aware, the webcast will always show the person speaking rather than the entirety of the committee. To ensure an orderly meeting, I'm going to outline again the few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either floor, English, or French. Please select the language that you prefer in which you are speaking. For members participating in person, proceed as you would usually when the whole committee is meeting in person in the committee room. Keep in mind the directives from the Board of Internal Economy regarding masking and health protocols. Before speaking, please wait until I recognize you by name. If you are on the video conference, please click on the microphone icon to unmute yourself. Those in the room, your microphone will be controlled as normal by the Proceedings and Verification Officer. A reminder that all comments by members and witnesses should be addressed through the chair. When you are not speaking, please make sure your microphone is on mute. With regard to the speaking list, the committee clerk and I will do our best to maintain the order of speaking for all members, whether they are participating virtually or in person. As is my normal practice, I will hold up a yellow card for when you have 30 seconds left in your intervention, and I will hold up a red card for when your time is up. Please try to respect the time limits so that all members have a chance to have their round of questions. Pursuant to Standing Orders 1082 and the motion adopted by the committee on Thursday, November 5th, 2020, the committee is meeting today for a briefing on the Office of the Competition Bureau of Canada. I'd like to now welcome our witnesses. We have today with us Mr. Matthew Boswell, Commissioner of Competition, Mr. Anthony Desrochers, Deputy Commissioner, Competition Promotion Branch, and Ms. Lila Wright, Associate Deputy Commissioner, Competition Promotion Branch. Our witness will present for 7 minutes, followed by rounds of questions. With that, I now turn it over to Mr. Boswell. You have 7 minutes. The floor is yours.
Thank you, Madam Chair and members of the committee. Thank you for the invitation to appear before you today. This committee has a long history of advancing the public policy discussion on competition issues.
Mr. Boswell, could I ask you to put your microphone a little closer to your mouth, please?
Sorry.
Thank you.
Canada needs more competition, and your committee's efforts consistently bring competition into sharper focus. We are happy to support your important work. In these opening remarks, I want to highlight the importance of competition in responding to COVID-19. Although we face an uncertain future, an emphasis on competition today will not only protect consumers when they are at their most vulnerable, but will also ensure that our rebuilt economy is one where competition drives lower prices, improved productivity, and increased levels of innovation to the benefit of all Canadians. The Competition Bureau, as an independent law enforcement agency, ensures that Canadian consumers and businesses prosper in a competitive and innovative marketplace. The Bureau does this by administering and enforcing the Competition Act. Under the Act, the Bureau investigates a wide range of anti-competitive behavior. As Canada's competition expert, the Bureau promotes pro-competitive government policy. L'application de la loi en matière de concurrence est...
Government competition enforcement is more important than ever. Businesses can use crises like the COVID-19 pandemic as cover to consolidate market power or engage in anti-competitive activity. Vigorous competition enforcement stands opposed to those who wish to capitalize on uncertainty and fear. Since the first weeks of the pandemic, the Bureau has taken action against businesses making unfounded or misleading claims that their products could prevent, treat, or cure COVID-19. As a result of our interventions, most of the businesses have taken corrective action, pulling products that raised concern from their shelves or stop the claims. The Bureau continues to monitor the situation and will take further action as needed. We have issued a statement which continues to apply, providing the marketplace with a principled yet flexible approach to competitor collaborations designed to support crisis response efforts. Even though this is a significant departure from our traditional enforcement approach, we felt it was the right thing to do in these exceptional circumstances. Sadly, in the months ahead, it is possible that we will see a rise in merger transactions involving failing businesses. In assessing these transactions, we must maintain our normal rigor and analytical framework. Relaxing our standards in a crisis period could cause irreversible enhancement of market concentration, leading to deeper and long-term harm to consumers and the economy. Finally, we continue to prioritize competition in digital and data-driven markets. For example, in the past 6 months, the Bureau has undertaken a number of actions in this area, including a recent settlement with Facebook related to deceptive privacy claims, our ongoing investigation into business practices of Amazon, and our participation in the CRTC's review of Canada's wireless industry. The Bureau will continue to do everything in its power to protect consumers and businesses from anti-competitive activity throughout the COVID-19 pandemic.
Enforcing the law, the Bureau also champions pro-competitive government policy. Competition-friendly policies can aid economic recovery by stimulating entry, productivity, and innovation. To support these efforts, the Bureau has released a competition assessment toolkit for policymakers. This step-by-step guide helps policymakers to maximize the benefits of competition for Canadian consumers and businesses. We urge governments across Canada to use competition as a focal point in facilitating economic recovery. In the face of a global pandemic, we can be sure that our focus on competition today will empower consumers and promote productivity, innovation, and economic growth during our recovery. The Bureau will continue to do all that it can to build a stronger and more competitive Canada. Before fielding your questions, it is important to note that the law requires the Bureau to conduct investigations confidentially and keep confidential the information we have. This obligation may prevent us from discussing some past or current investigations that may be of interest to members of this committee. Finally, I'd like to once again thank the committee for the opportunity to appear today. We look forward to your questions.
Thank you very much, Mr. Boswell. And with that, we will start our first round of questions. Our first round of questions goes to MP Root. You have the floor for 6 minutes.
Thank you very much, and thank you for the presentation. So you were mentioning that part of your job is to protect consumers throughout the pandemic. And throughout the pandemic, we've seen food security issues in some places in the country. We've seen issues with grocery giants who are trying to gouge producers and food processors. And we've heard testimony of this at the Agriculture Committee as well from folks who are in the industry. And we've seen record profits by the grocery giants. Like we're talking over nearly 350 million by one grocer in the last quarter. We're talking a 12.5% increase from last year in their profits. And at the same time, Metro, Loblaws, Walmart, they want to impose extra fees on top of the fees they already charge processors and farmers for the privilege of selling to their stores and supplying them with goods. And so, at a time of a pandemic when food security is of utmost priority, I'm wondering, and I have asked the Prime Minister about this, and I'm wondering, he had said that he was going to ask the Competition Bureau to investigate the fees that are charged to producers and processors by grocery giants. I'm just wondering, has he asked you to investigate this and with respect to the grocery retailers?
Thank you, Madam Chair, for that question from the honourable member. Of, of course, the Bureau is very much aware of these issues. They have been at the front of media coverage for some time, and I can tell you today that we are already engaging at the federal, provincial, territorial level with respect to these particular issues, sharing our expertise on competition. The Bureau is Canada's competition expert, and we will continue to do so going forward. Of course, in our work, we are guided by the facts and evidence. The reality is that competition law in Canada does not provide for a tool to regulate imbalances in bargaining power. And from our perspective, that is what this situation appears to be.
Point d'ordre, Madame la Présidente.
I'm sorry, Madam Chair. Yes, Mr. Lemire. Translation is not working. I don't think the witness is speaking close enough to his mic, and I'm really interested in the answer, and I'd like to be able to hear it.
Could you put your microphone closer to your mouth so that translation can pick up the sound, please?
Yes, I'm sorry.
Thank you.
Sorry, it's not working well. It was working well yesterday. J'espère que M. Lemire peut...
I hope Mr. Lemire can hear me. I think you'd need to speak a little more for us to be able to tell.
this issue and repeat briefly what I had said. The Bureau is, of course, very much aware of these issues with respect to retailers and their suppliers. We are already engaging at the federal, provincial, and territorial level with respect to this issue, sharing our expertise on competition issues. And that said, I did make the point, and it's important to make today, that competition law in Canada does not regulate imbalances in bargaining power. There's no provision in our act that would specifically address that. We know as well that this has been an issue in other jurisdictions around the world who have taken different actions because their legal framework has permitted that. So,
You. Given that there's a concentration that 80% of the grocery market is controlled by only 5 major chains or retailers, would there be a grounds for an investigation of an abuse of dominance? And if you could elaborate on what the definition of an abuse of dominance would be.
yes, so we've discussed these issues in quite detail as a result of an extensive investigation we conducted into Loblaws business practices in 2017 and looked at potential issues of abuse of dominance. As I say, this situation appears to be power, something the Competition Act does not have specific powers to deal with. Abuse of dominance is effectively, in short version, where a company has a dominant market position and engages in anti-competitive acts with an intended negative effect on a competitor, and that conduct results in substantial lessening or prevention of competition.
So, could you also explain perhaps what the grounds and what is the process for the Competition Bureau to set up a competition tribunal? And is this something that you would look into on the issue of grocery retailers?
So we have a prosecutorial model in Canada for competition law violations, and we must bring our civil cases to the Competition Tribunal of Canada and establish to their satisfaction the elements of any violation of the Act, which is what we do when we bring um, allegations of abuse of a dominant position, cases that we've brought in the past.
Thank you very much.
Thank you very much. We'll now turn to MP Assasi. You have the floor for 6 minutes.
Thank you very much, Madam Chair. Thank you, Mr. Boswell, for appearing before this committee. If I could just follow up on the questions that Ms. Rood was asking. So in your opinion, do the abuse of dominance provisions in the Competition Act, are they of any utility insofar as the issue that Ms. Rood raised and with respect to the big grocery companies?
It would seem that this is a situation of imbalances in bargaining power and not a situation of abuse of dominance. That's the Bureau's perspective, and having done extensive work in this area in a previous investigation, consistent with our previous findings in that matter. Now, I should point out, sir, that as I made reference to, other countries have been able to adopt codes of conduct in this area. The Bureau doesn't have the power to create or enforce a code of conduct that would apply to large grocery retailers.
So, in your opinion, having looked at other jurisdictions, would the adoption of a voluntary code of conduct help with respect to this particular issue?
I suppose, sir, that the devil is always in the details, as they say. A code of conduct can be helpful. We've seen in the United Kingdom a code of conduct that has generally received a positive reaction and has appeared to be helpful to some of the issues between grocery retailers and suppliers in that jurisdiction.
Thank you for that. Now, you said that you have your bureau, in fact, has been working with enforcement authorities in other jurisdictions to grapple with this issue. Given the provisions of the Competition Act, are there any other provisions that might possibly assist in terms of ensuring that this dynamic and this phenomenon does not continue in our country?
From our perspective, sir, there isn't a clear tool in the Competition Act to deal with imbalances of bargaining power.
Thank you for that. Now, if I could move to a very different area, which is the area of innovation. I know that in 2019, for the first time, the Competition Bureau announced that you would be instituting a chief digital enforcement officer. For the benefit of all the members of this committee, could you share with us what the significance of that appointment is?
Yes, Madam Chair, this is part of the Bureau's overall focus on being a world-leading competition agency in terms of all that we do in the digital economy. We were successful in bringing in a chief digital enforcement officer from the outside of government to assist us in all aspects of our work in terms of the digital economy. That includes both internal focus, digital strategy for the Bureau, making sure we have the right digital tools to conduct our work as efficiently and effectively as possible, as well as making sure that we're considering and analyzing the issues, the competition issues at play in the digital economy, so that we're well positioned to either provide pro-competitive advice on policies, or we're well positioned to bring enforcement action in terms of the digital economy.
Thank you for that. Given that your mandate is to enhance productivity and innovation, with leaving that particular position aside, are there any other tools that your Bureau utilizes to enhance innovation?
Absolutely, sir. I mean, competition is the key or a key driver of innovation in any market-based economy. Competition forces competitors to consider innovative approaches at every turn. And in fact, this is something that was, pointed out by Tobias Lutke, the CEO of Shopify, that embracing competition every day, looking at your competitors, seeing how you can do better than them, how you can provide innovative new products. That's what drives innovation in our economy and economies around the world, and drives productivity.
Thank you for that. Now, I'd be remiss if I didn't also touch on another new practice that has been adopted by your Bureau, which is the new competition enforcement framework that Canada entered into with the US, New Zealand, Australia, and the UK. Could you provide us more details on that and provide us your assessment as to how significant that is?
Yeah, yes, absolutely. And thank you, Madam Chair. Thank you to the member for bringing this up, because this is tied once again to the digital economy and the global nature of the economy.
Madame la Présidente, la qualité de l'interprétation ne nous permet pas de pouvoir avoir accès à la réponse de M. Boswell.
D'accord, merci beaucoup. Mr. Boswell, any possibility of getting that microphone a little closer? We're actually out of time on that round, but I'll let you just finish that response, and we'll try the translation at the same time.
Yeah, I apologize. Désolé, Monsieur le Maire. The point is that we've entered into numerous international cooperation agreements with our partners around the world. International cooperation in competition law enforcement is vital in a digital economy, in a global economy. Our recently announced agreement is part of our emphasis on cooperating to be able to help Canadians.
Merci beaucoup.
Thank you very much. MP Lemire, you now have 6 minutes. Thank you very much. So my first question, within your mandate, Mr. Boswell, my understanding, you have the power to make recommendations, but you also have a power of coercion, and you want to be able to stop people from going into a certain market, and that's something that we've an anti-competition behavior. What can you do if there is a problem for when you have somebody in a dominant position?
Yes, as I indicated, there is an abuse of dominance provision in the Competition Act, Section 79 of the Act, that should we...
Madame la Présidente, je suis obligé d'arrêter la traduction.
I'm sorry, I have to stop because, well, I don't have translation, and I understand the interpreters because the quality in English language, it's very difficult. So what can we do to improve the situation here to solve this problem?
Not have a headset with a microphone, is that correct?
No, Madam Chair, I'm going to try a different microphone. Perhaps I could ask my colleague, Monsieur Durocher, to answer Monsieur Lemire's question, and I'll switch microphones.
Okay, and for Monsieur Durocher, I see that you have same kind of headset, so if you can put the microphone close to your mouth, that would be helpful. Thank you.
Certainement, Madame la Présidente.
Yes, Madam Chair, to answer the question, to bring recourse if there's abuse of dominant position in Canada, we have to conclude that this was actually the case, and there are 3 elements that are needed to establish that with evidence. And then you can either have an agreement between the parties, or if that is not able, then you bring that to the competition tribunal, and that is a specialized federal tribunal, And to do that, you have to have witnesses and you have to have evidence to prove your case. And it will be the tribunal that will make a decision. And they can set up a recourse, a remedy for that to solve the problem, or any other remedy that would solve the problem. So what is the process if there is an official complaint? There were three complaints that were brought against Roger. Are there any sanctions that would apply, and how do you verify it? I could give you other examples. In my region, we have Videotron and Bell, and we have Cogeco and Videotron also, who have made complaints against Bell. So what exactly is the procedure that you use at that point? Madam Chair, the procedure for an inquiry within the Competition Bureau is we have to go and get the facts and the necessary evidence to see if there was a violation of the legislation and abuse of the dominant position. And to do that, the investigations are done by a group of investigators that will go and get the necessary facts with witnesses from and they will analyze this data. And so it is. This is a very deep inquiries to ensure that we are making decisions that are really based on fact and evidence. And once the investigation has been completed, often then we will move ahead with discussions and negotiations between the different companies in question, so to see if the problems can be resolved without going before the tribunal. And there can be an amicable agreement, or it can go before the tribunal. So, but if you don't have an agreement between the parties, then we will be filing an application with the Competition Tribunal. And to do that, then you have to have your file completed, and you go through the process. And of course, you have to then apply the decision of the tribunal. And so that follows this investigation. Based on your investigation, it would take at least 4 providers, and where I am in Temiskaming, we don't have those numbers. It's hard to have 4 suppliers. So, but what do you think? Should these suppliers be independent from the main companies, so that not just a branch? Is that part of a solution? So can they between an independence between the distributor and the provider? Would that help? Madam Chair, in the case of the service providers, this is relative to a recommendation that we did with the CRTC, a recommendation that we made for the wireless sector, and the fact that there would be a 4th competitor within a wireless environment that would allow for prices to drop. What was done for the wideband, if there were a sector with the same players, and if the commercial reality were different, then we need to ensure that there would be participation in the CRTC consultation process to ensure that they have the same level playing field in all aspects of competition, also with respect to methodology to evaluate access for independent parties. Our role in our investigations in any given, when there's a problem of access, we need to determine the fact and the evidence, and that is on a case-by-case basis that we do that. I'd like to ask another question. The question I have is the wholesale supplier, do they have to be independent of the distributor so they could have better prices? Would that not be a way to have a lower price internet? You don't have any more time left. Well, I would say that this is really the CRTC that makes that decision. For us, we can investigate if the facts do show that there is an abuse of a dominant player. Thank you very much.
Questions goes to MP Massé. You have the floor for 6 minutes.
Thank you, Madam Chair, and I thank our witnesses for being here. As NDP critic for consumer issues for a number of years, I want to thank the Competition Bureau, the women and men who have ably served our country for a long time. In fact, I've been calling for reformation of the Competition Act because, quite frankly, it's time that we actually took the training wheels off and provided more empowerment, because corporations have often treated Canada as a colony with regards to the treatment of Canadian consumers and competition. When you compare even the United States, I had a private members bill back in 2009 that went through this House of Commons, was supported, and actually went through this committee that resulted in a voluntary agreement for the automotive aftermarket. The problem that we have is the voluntary agreement, again, is now being abused. Has there been any investigation with regards to the complexity? Because the voluntary agreement for that particular issue, and this is the right for cars to be fixed and repaired in the aftermarket, it didn't include a digital chapter to it. And I'm just wondering whether there's been any work or investigation, if you could indicate, with regards to that part of the bill, because what was happening for other members to know is that the United States were allowed to get aftermarket fixes to their vehicles, equipment, software, a series of different things, which were denied in Canada. So ironically, in a Windsor, you could get your van in the aftermarket fixed over in Detroit, but you couldn't get it fixed over in here, Windsor, because the companies wouldn't provide that information. It resulted in a voluntary agreement, but I'm just curious as to the state of that situation right now.
Thank you, Madam Chair. Hopefully this microphone is better for translation purposes. That's to answer the honourable member's question. That's not something that I'm familiar with and can provide any meaningful, detailed response today, but I'd be happy to follow up offline with the honourable member on that issue.
Great, thank you. That's fine, and it's just recently become more challenging with that voluntary agreement. And I guess from there, what type of benefit do you think that consumers would enjoy if the Competition Bureau was allowed to actually do criminal proceedings? I know other countries, and can you comment on other countries that have the ability to actually have their competition laws enforced through criminal proceedings? That modernization might more empower the ability for the competition to get readily results.
So, thank you for that question. What I can tell you, Madam Chair, is that in certain aspects of our law, we do have the ability to bring criminal prosecutions. And in fact, we do bring those. How it works is we investigate. We're akin to a police force conducting a thorough investigation, following the evidence where it leads, and we then refer the results of our investigation to the Public Prosecution Service of Canada for certain particular offenses set out in the Competition Act that are criminal. Perhaps the most well-known is what we refer to as cartel offenses, which are agreements between competitors to fix the price, restrict the supply, or allocate markets. We also have bid rigging, which is criminal. And over the last 10 years, approximately, as a result of our criminal prosecutions, companies have paid over approximately $120 million in corporate fines, and dozens of individuals have been found guilty of criminal offenses. So, but it's not not the whole act, but there are certainly criminal offenses.
Yeah. Well, that's the point. Is that there maybe a more modernized approach for encompassing the whole act. I guess because here's where I'm going with that. When you look at the most recent issues we've had related to the digital economy, being Facebook, Amazon, your CRTC involves the digital economy, Ticketmaster, the Apple battery scandal, all of those are relating to a new modern economy. Perhaps is it not a time to review the act to be more robust, or at least to have that discussion? If there was increased capabilities, do you think that the people in the Competition Bureau are up to new types of I guess, enforcement provisions or investigation provisions, provided the proper supports legislatively.
Well, thank you. As the committee may know, the Competition Bureau is part of the broader Innovation, Science, and Economic Development Ministry, and ISED itself has control over competition policy in Canada, and of course, elected officials are responsible for any amendments to our law. That said, it's in our view, it's always useful to review law to make sure it's fit for purpose. And Minister Baines actually wrote me an open letter in May of 2019 asking our team at the Bureau to look into all aspects of our law to make sure they were fit for purpose. We've been working hard on that, and we've done work on that, and hope to see progress on that.
Okay, so we can expect then, hopefully, by the end of this year, maybe perhaps something that would be publicly disclosed with regards to some type of potential change.
I can't comment on that. We're working with officials that ISED as hard as we can.
Fair enough. Thank you. Thank you, Madam Chair.
Thank you very much. We'll now move to the second round of questions. Our first round goes to MP Dreeshen. You have the floor for 5 minutes.
Well, thank you very much, Madam Chair. And I just a couple of questions. I know that in recent years, the European Commission has been much more active in enforcing competition rules on big tech companies such as Amazon, Google, Facebook. Does the Competition Bureau have enough resources and legal powers to effectively enforce competition rules against big tech companies? And more importantly, does the Competition Act provide high enough penalties to discourage big tech companies from engaging in anti-competitive practices?
Yes, Madam Chair. I thank Mr. Dreeshen for that question. The Bureau, in terms of resources, we strive every day to get the absolute most out of the resources that we have to be as efficient and effective as possible, always looking at our processes and how we could do better and what tools we could use to do better. That said, I've spoken publicly multiple times about some of the challenges the Bureau faces with respect to administering and enforcing the Competition Act in the digital economy. We've had a veritable explosion of data in the world, and of course, law enforcement agencies have to deal with the data that we receive on cases. The amount of data we receive has gone up 6 times. The cost of cases has increased dramatically. We have had our budget's been about the same for 10 years, and so in real dollars down about 10%. And we have fewer resources now than we did 15 years ago in terms of people working on files. So, outsiders have called on the Bureau to get more resources, including the C.D. Howe Institute, as well as the Global Competition Review and its annual review of competition enforcement agencies around the world. So we're doing the best work we can in the public interest to protect Canadians. We've brought cases. We've investigated Google. We've brought a case against Amazon in 2017 with respect to some of their pricing practices. We obviously resolved the matter with Facebook earlier this year in terms of privacy representations. And as some members of the committee may know, we have an active investigation into Amazon. So we, the good people at the Bureau, get up every morning, and our mission is to serve the public interest, do as much as we can to enforce and administer the law and to promote competition in Canada.
Thank you. When you mentioned the global competition review, it makes me think about some of the other predatory practices that other countries are using, and primarily I think about China. If you take a look at what is happening in Africa, the way in which they embed themselves in the infrastructure projects that are there, environmentally and human rights wise, serious issues there, so I'm just curious whether or not you have your finger kind of on the pulse of what is happening in those, or is that a different department that would look at those types of investments and the predatory practices?
Yes, absolutely. Our focus day in and day out is on competition issues in Canada,
Okay.
doing everything we can to make the Canadian economy as competitive, healthy, vibrant, and fair as we can.
So to that particular point, you mentioned earlier that you have aid in a pro-competitive work, and during your address, and that you're trying to maximize that. My concern or my issue that I'd like to have us address is are these provincial initiatives or federal initiatives when we're talking about pro-competitive work? And the reason why I say that is we continually we continually hear how the government is saying, well, we want to push forward into green technology and all of that. Whereas by doing that, and if that's where you have to concentrate, provincial initiatives and things to try to get energy into the world to take care of the problems that the Chinas are doing in Africa and so on, seems to be left on the back burner. I'm just curious whether or not whose initiatives will you be pushing when you try to look at pro-competitive work?
So our work in terms of advocating for more competition in Canada, promoting competition, is at all levels of government, sir. We do work with municipalities on how their regulations could be more pro-competitive, provinces, territories, and the federal government. We're trying to help at all levels of government.
Thank you very much.
Thank you very much. Our next round of questions goes to MP Erskine Smith. You have the floor.
Thanks very much. Thanks, Commissioner, for joining us. At a recent grocery innovation conference, you said, in general, communications among competitors regarding employee wages would seem to be unrelated to an effective response to the pandemic. And I heard of such discussions with concern in relation to our national grocers and their cutting of pandemic pay. Now, I've tried to wrap my head around what could have been the rationale for those discussions. I can't think of any rationale except for collaboration to reduce employee wages specifically. Could you think of another rationale?
I think that, as I said when speaking to the Canadian Federation of Independent Grocers, that the concern here is the slippery slope when competitors, certainly at very senior levels, are having conversations. There's a slippery slope towards what I referred to earlier when answering Mr. Mass's question with respect to cartel conduct. And that's why I flagged that issue in particular with respect.
I'm glad you did. I'm glad that you flagged it to them directly. And I would also say I appreciate the November 27th statement on wage fixing. Now, when I compare our interpretation of our own laws out of justice and out of your statement versus the FTC guidance, it does seem pretty straightforward to me that if that same conduct that we saw among our national grocers had occurred in the United States, it would have amounted to naked wage fixing, and FTC could have criminally investigated. You don't have that power, though.
That's what we clarified to the Canadian public last Friday, is that agreements between competitors with respect to things such as wage fixing or no poach agreements are not captured by our criminal powers. As a result of 2009 amendments to the law removing the word purchase from that particular section of the law, we got the legal advice that we couldn't bring those cases criminally. And of course, as you point out, that puts us out of sync with our biggest trading partner, where the U.S. Department of Justice Antitrust Division has indicated that those types of agreements, if the agreement is established, that's obviously an important first step in any sort of investigation of that sort, will be prosecuted criminally in the United States.
And I note that the FTC also says mere communication can amount to an agreement in certain circumstances. Now, I would also note a limitation, my read of Section 90.1, while it could, in theory, apply where an agreement must be existing and proposed. In this case, it would have been a past agreement. So even there's a limitation that we might well want to address. When past commissioner, your predecessor, Commissioner Peckman, recommended expanding the Act's purpose beyond protecting consumers to include the fair treatment of labor, you referenced a 2009 change we could potentially reverse. Do you think our laws ought to be consistent with the United States?
I think that for a variety of reasons, convergence of competition laws, certainly within North America, is something that would be beneficial in multiple ways, including beneficial to the business community, because they would understand that the laws that they must comply with are the same or nearly the same in both Canada and the United States. So there's value there, and there's clearly, as a result of our statement last week, there's now a divergence on that particular issue, which, as we pointed out in our statement, is a serious issue for Canadian workers.
I appreciate that, Commissioner. Now, we are a country of oligopolies, and there is great inequality of bargaining power in the context of oligopolies. And you've noted a couple of times now in your testimony that the Competition Act really does not address directly inequality of bargaining power unless it amounts to an abuse of dominance. Now, we see in Australia a conversation about a code of conduct as between news media and platforms and using a competition lens to address that inequality of bargaining power. We also see in the UK a code of conduct used as between national grocers and producers. And it's been brought to my attention that we should have a code of conduct like that for our national grocers and producers to address that inequality of bargaining power. Now, that could be a provincial conversation. Do you think there would be a way, though, to amend the Competition Act to allow for you and your office to impose codes of conduct where you deem it necessary to address that inequality of bargaining power in the course of oligopolies?
Well, that's a good question. It's not something that I have a ready answer for in terms of the various issues that might be at play with that in terms of provincial, federal jurisdiction, those sorts of things. But as you point out, a code of conduct in the United Kingdom has been well received.
Thanks very much.
Thank you.
Thank you very much. Notre prochain tour, c'est député.
We now have MP Lemire. You have 2.5 minutes. Thank you, Madam Chair. Earlier, you mentioned, Mr. Boswell, that there was an increase in merger during the pandemic period, and we're looking at a concentration of the market that could be unfortunate in the long term. Is the impact Cablevision? This is a branch of Bell, and they're not giving essential services to the population because they're saying there are not enough people. For example, to television at $25 that they need 20,000 Guilan, which is not the case in Abitibi and Ramos. So are you aware of that situation? And can Bell, through their company, can they not respect the responsibilities they have? Thank you, Madam Chair. My colleague, Mr. Durocher, will answer that question. Yes, I'll be pleased to answer. To come back to the first portion of the question, the competition law, companies have to give us notice and they have to give us information. And if they come to a certain threshold, financial thresholds, so that we can look at the mergers. With respect to commercial activities of certain companies who are going to decide to be present in a given market or not, I think that that's really a decision that the company make themselves based on their commercial interest. What's important for us is to ensure that there are no anti-competitive behaviors and an abuse of a dominant position or the buying up of a competitor in any given market. Mr. Durocher, for your answer, in the region, there can be unequal situation for remote situation where you don't have much population. One of the main problems that we've seen for internet in the region is that you don't have the poles and you don't have the networks there with the big providers. So is this the same? It's the same thing in Quebec. There are no delays when you want to have access for these poles, but in the case of Bell, it does happen. So I do believe this is anti-competitive behavior. Thank you very much for the question. Answer: I can't make. I can't speak to you about that issue because we are involved in that. We're following the recent development, and we also need to let you know that when the CRTC will be looking at this issue, this is something where we could intervene to give our point of view from the perspective of competition, because it's very important with respect to the poles. It's important for the deployment of 5G across Canada. So there is a role for the Competition Bureau to give their opinion with respect to the competition of that. Thank you very much. Thank you very much. I'll let you have a little bit of extra time to answer the question. The next round is Mr. Massey, 2.5 minutes.
Thank you, Madam Chair. Part of the challenges for a country like Canada is because we've become a branch plant economy in many respects, aside from some few domestic champions for headquarters here in Canada. A good example is the lack of use of the Investment Canada Act to protect Canadian iconic companies like Rona, for example, that's known owned by Lowe's. And hence, only places like, companies like Burger King that wanted to put its headquarters here to tax evade in the United States and put up false offices really in Toronto and other regions. We don't have the decision makers here as much. So how much of a disadvantage is it for us, say, for example, with the United States, not to have greater cooperation amongst our laws and consistency? For example, in Windsor here, to build our minivan, which is a world-class vehicle, it literally crosses the border back and forth 7 times, and there's a whole regulatory regime that protects consumers aside from the aftermarket issue I raised, but the building of it and the quality in a series of things are consistent for the consumer. How important with the digital economy is it for us to get further cooperation legislatively with the United States to protect consumers?
Thank you, Madam Chair. What I can say is that we do cooperate as an enforcement agency, cooperate and collaborate extensively with our American counterparts. We have deep relationships with them, and we share information on cases or potential cases on a regular basis in many aspects of our enforcement work, which we believe provides a better result for Canadians, a better result on the U.S. side of the border when we are working together on these matters. But of course, as I pointed out earlier, there are some areas where our laws diverge, and those areas could be examined if there was a desire by elected officials to bring our laws closer together.
Would that result in better consumer, protections and repercussions in terms of benefits, similar to what Americans get on different cases? Because clearly for Toyota, for example, it was clearly different what took place, Facebook, a series of things. Would that help kind of merge those two types of penalties and repercussions?
Well, review of sanctions is something that obviously came up following the Facebook resolution in Canada and was commented on extensively.
Thank you very much. Our next round of questions goes to MP Cumming. You have the floor for 5 minutes.
Great, and thank you for the witnesses being here today. I want to start off with a discussion around the concentration that's happening with the big tech, large players. You mentioned earlier that you've had a couple of rulings related to Facebook and Amazon, but given the nature of their business and the direction that it's going, how concerned are you with the concentration that they will, like market concentration that they will have as major players in Canada? And what tools do you have in your tool chest to be able to hold them accountable for predatory practices, market dominance?
Yes, Madam Chair, I thank Mr. Cumming for that excellent question. This is an issue that competition agencies around the world have been grappling with. That is how these digital markets, platform markets, can be to a certain extent winner-take-all markets, where the competition is for the market, not in the market. And the Bureau's been very alive to these issues and working on these issues for several years. In September 2019, we put out what we refer to as a digital enforcement call-out, where we had a white paper that an issues paper that explained to the Canadian public the sort of key competition issues in these big in these digital markets, and how they could tip to concentration of one or a small number of companies, and also what sort of anti-competitive practices to be on the lookout for in these markets. That's similar to our call out for information earlier this year about conduct in Amazon. That's obviously an ongoing investigation, so can't get into the details. But these are serious issues that, as I say, our colleagues around the world are grappling with, and there's been extensive work done in this area. The Bureau is on it and paying close attention. And where we find the evidence, where the evidence leads us to bring a case, we'll bring a case.
I completely agree with you. It's a significant issue and actually made far worse with the pandemic, and giving that market dominance has actually increased significantly. I'm wondering if your department has spent much time reviewing the provisions within C11 with data privacy and some of the data regulations, and are the definitions strong enough? Have you done a thorough review, and can you share with us any opinions that you might have either right now or follow up with something in writing?
Yes, Madam Chair. Thanks again for the question. So we haven't done a deep dive on the bill before Parliament. What I can say, though, is that there are certainly aspects in the bill that we view as positive, including giving the Office of the Privacy Commissioner greater ability to share information with the Bureau, and a small amendment to the Competition Act to provide for sharing between the Bureau and the Privacy Commissioner. So that we view as positive. Also, the notion of data mobility, which is set out in the bill, to be, I guess, expanded upon, or more detail to come in regulations to follow. But data mobility, to my mind, is a synonym to data portability, which can have tremendous competitive benefits in the economy. It allows for greater switching between services in multiple different sectors. So we have, of course, looked at the bill. As I say, we haven't done a deep analysis, but on our initial review, there are elements that we view as positive for our work and our ability to work with the Privacy Commissioner, because there's a great intersection more and more between competition and privacy.
Were you not asked to provide input prior to the drafting of the bill? Because this bill has very strongly connected to the work that you do.
Yeah, it wasn't a situation where we were asked for input.
I'm a bit taken back by that. I'm surprised by that. Shouldn't your department be thoroughly involved in a bill of this type nature?
All I can say is that we weren't asked to provide input.
Thank you.
Thank you very much. Our next round of questions goes to MP Jasic. You have the floor for 5 minutes.
Thank you very much, Madam Chair, and thank you to the witnesses for coming today. You, of course, have heard from my colleagues a number of our frustrations in relation to competition in Canada, whether it be the large grocery chains, whether it be the large purveyors of telecommunication systems. Certainly, this committee has heard what I think a lot of us may feel, certainly I do, that somehow competition isn't really working very well. So I'm very pleased to hear that since May 2019, you've been working on some suggestions for Minister Baines to potentially amend the legislation, and you've given us a few hints in some areas where you may be going with that, codes of conduct, convergence with our largest trading partner, the United States, etc. I'm interested on the enforcement side. If you feel there's a civil case, you go to the competition tribunal. If potentially criminal charges might be laid, you go through the director of public prosecutions. Do you see any changes there that could be helpful for your work that you may be looking at for the future as well?
I think in terms of our ability to, well, first of all, Madam Chair, thank the honourable member for the question. Our ability to bring cases to either the Competition Tribunal or to the criminal courts via the Public Prosecution Service of Canada is obviously fundamental. We have a prosecutorial model. We've talked a bit today on the civil side about the ability to have financial sanctions that are more scaled to the size of the enterprise that we're dealing with. And this is something that I perhaps should have brought up to Mr. Cummings' question in the sense that another positive development from our perspective of Bill C-11, the privacy bill, is that the financial penalties in that bill are as scalable. That is, they're based. They can be based on a percentage of global revenue, which is something that many of our partners around the world have those types of financial penalty provisions in their acts, and it in my view, it's important to encourage compliance with the law, to have sanctions that reflect the volume of commerce involved and the revenues at play.
Okay, thank you. That's very useful, and I think it ties in quite well with what my colleague MP Massey was saying in terms of we're such in essence, a small player in terms of the actual potential volume of activity locally, but these are huge corporations that obviously um, would respond to potentially more onerous sanctions. So, am I sort of understanding you correctly that you would see sanctions, fines, potentially matching the scale of the operation of the particular company?
I think I think it's something that's certainly worth considering in sort of a comprehensive review of the act. I should point out there as well, there are areas of the act where there are no financial penalties available at all. For example, in relation to civil agreements between competitors in Section 90.1 of the Act, which is the alternative section to examine wage fixing, there's no ability for a financial penalty in that section whatsoever.
I think I'm almost out of time, so I will hand over to my next colleague.
Thank you very much. And we'll now start the third round. And our first round of questions goes to MP Genereux. Genereux, you have 5 minutes.
Thank you, Madam Chair, and again, a pleasure to be here with everybody. Mr. Boswell, thanks for joining us. I'm looking at your budget, and your budget in 2009 was 40 million. Your budget in 2019 is 2020 is 37 million. Your employees essentially have stayed the same. I guess you're down one employee. So unless that one employee was making $3 million, I assume that there's essentially your everything has been kept about normal for that period. I suspect the pandemic itself has only accelerated a lot of the requests or need for the Competition Bureau. Um, the big tech is interesting, but I'm also curious if there's practical examples of like hand sanitizers, PPE perhaps that you can share with us, and just how again this pandemic has accelerated some of those concerns.
Yes, Madam Chair. Thanks to the honourable member for the question. Um, as I alluded to in my opening remarks, uh, um, shortly after the declaration of the global pandemic, the Bureau took the unprecedented step of issuing guidance to the marketplace in terms of uh, a willingness to exercise enforcement discretion for competitor collaborations that were specifically designed to keep supply chains going so that critical goods and services could get to Canadians. We put that out, um, I think, in early April, and set out that if those agreements or collaborations between partners were time limited, very much focused on making sure that Canadians got the critical goods and services they need, then we would exercise enforcement discretion with that. But we also, of course, cautioned that we wouldn't tolerate any abuse of that indication to the marketplace.
And have you seen some abuse then? Some of that?
Well, what I was,
I guess grocers, big tech
go on,
aside, some of that.
I was going to say that, and sadly, this didn't come as a surprise to us, and in fact, we issued a warning within days of the pandemic starting, in terms of deceptive marketing practices to try and take advantage of the pandemic, false or misleading representations, products, saying they would either prevent, treat, or cure COVID. And within, as I say, within days of the pandemic being declared, we assembled a team, dedicated team to monitor the marketplace for these types of false or misleading representations. And as they came to our attention, we would send these companies warning letters rapidly saying that this conduct was likely offside the act, the representations were false or misleading, and call on them to change their conduct immediately. Fortunately, we did that with dozens of companies, and fortunately, the vast majority of them heeded our warnings, took down the representations, had products pulled from shelves, and that allowed us to make sure these in fact, dangerous false or misleading representations weren't out in the marketplace. We still have a team dedicated to this, monitoring this, getting complaints. We had a surge in complaints between April and June of this year, 2 times the number of complaints in terms of deceptive marketing practices. It didn't, sadly, as I say, it did not come as a surprise to me. There are always people who are willing to try and step into a crisis and make money off it. And in this case, it was, in our view, through false or misleading representations.
And heed the chair's warning and see a warning sign there. So I'll just sneak in a quick question then. It seems everywhere you go, there's different specific to hand sanitizers. Some are more potent in smell, some you barely smell. That just being one indicator. But then you also, it seems like every distillery across Canada has come up with a way to shift back to doing hand sanitizers. How connected are you guys with Health Canada and making sure that those hand sanitizers, because they inevitably have to get pulled off and then they get put back on. the shelves again once they've met that criteria. So I guess you probably don't have time to answer. I'm trying to be polite, but anyways, I guess something to think about. Maybe touch on another question. Thanks.
Thank you. So unfortunately, yes, you are out of time, but perhaps at a subsequent round, Mr. Boswell can answer that. Excellent questions, MP Jenner. Thank you. Our next round of questions goes to MP Johari. You have the floor for 5 minutes.
Thank you, Madam Chair, and thank you to the witnesses. It's quite an informative session. Question goes to Mr. Boswell. Mr. Boswell, in your recent speech to the Canadian Club Toronto, you argued that to ensure a strong economy and prosperous future for Canadian after the COVID-19 pandemic, it was necessary to take action in 3 vital areas: fostering competition in digital space dominated by global tech giants was one, developing a robust in telecommunication infrastructure underpinned by competition was the second one, and third one was prioritizing competition in regulatory environment at all levels of government. Can you talk about what action specifically the federal government can take to support this agenda?
Yes. Well, I suppose the third pillar is where the federal government and all levels of government can support this agenda, which is to examine existing or proposed regulations, as I say, at all levels, including municipal, to make sure that those regulations, obviously they may have other policy objectives, but that they're taking competition into consideration, that they're hindering competition as little as possible while also trying to achieve those other objectives. And in line with that, and as we flagged to this committee in a submission in May, we have developed a competition assessment toolkit for use by regulators across the country to bring that competition lens to their regulations. There's extensive evidence out there that Canada could benefit. It could be a great opportunity for Canada to really bring this competition lens to all our regulations in this country.
Yeah, thank you on that. Given our constitutional framework and the fact that you emphasize all levels of government, how can the federal government encourage other levels, the province and the municipalities, to prioritize competition in their own regulatory environment? And quickly, because I want to squeeze in another question from you.
I suppose leadership by example, and sort of coast to coast to coast embracing of a culture of competition in this country.
Okay, thank you. The federal government, as you know, the federal government recently introduced Bill C-11 for the protection and commercial exploitation of personal information and establishment of data protection tribunal. Section 14 of this bill would notably amend the Competition Act to facilitate cooperation between the Competition Bureau and the Privacy Commission. How does this bill affect your activities if Parliament enacts this in the near future, as its current form?
Yes, Madam Chair. I'm going to ask my colleague, Mr. Durocher, to answer the honourable member's question, because I'm going to try yet again a new mic, so I don't have to hold this up by my mouth for the next hour. So I'll turn it over to Mr. Durocher.
Sure, Madam Chair. In response to the question, I guess it creates a means to facilitate sharing of information between the Competition Bureau and the Office of the Privacy Commissioner, which can be particularly important in the context of investigations that would facilitate information sharing between us to make investigations progress. So from our perspective, the ability to share information with like-minded partners is particularly important, and that was certainly something that was welcomed in our preliminary review of the bill.
I have about 30 seconds. I'm going to squeeze this one. Hopefully you would be able to answer that. From a competition perspective, what balance should the federal government aim to achieve between protecting individual privacy and fostering innovation in the database market. $15 anyone?
Yeah, no, I'm happy to answer. I wasn't sure if the commissioner was back on. Obviously, in a data-driven world, things like data portability and data mobility are key to empower consumers with their own data, which in turn can facilitate competition. But we recognize data is critical to drive innovation as well, and to enable companies to improve the quality of their products and their offerings in the marketplace. But certainly from a competition perspective, empowering consumers to switch providers with their data through data portability is a very important notion in a digital world.
Thank you very much. Notre prochain tour.
We now have MP Lemire for 2.5 minutes. Mr. De Rocher, Mr. Boswell, when there's a question between the needs of competition and the need for intervention of the state, when it's is it okay for people to be in the market when we're talking about internet access? Answer. This is a great question. For us, our role is to ensure that within the markets that competition be healthy, and that there's no dominant parties in the communications market. There may not be a business plan, or it may not be profitable to offer services in a given region, and so we see the role of the state to be able to favor the deployment of services, broadband services across these areas. And so there may be representations that we can made by our bureau and to bring evidence before the CRTC when they have a hearing, so that they can become aware of the competition and they can take that into account in their decisions. This responds in part to my second question, but I'm still going to ask it. Where's the line between the need for competition and the need for the intervention of the state? In the case of Bell Canada or Air Canada, when essential services, when it is a question of essential services to the population, is it really right that people that be left in the hands of the free market? Answer. To be able to answer that question, I would say that the Competition Bureau does favor the free market system for there to be competition and to have innovation and low prices. And in some cases, the market does not work. And so this is where you can see the role of regulations to be able to correct situations in the market. And it is when you go across the threshold that is where our intervention of the Competition Bureau with respect to the upholding of the law, there may be intervention through regulation so that we can, and we do share our opinion on competition. Thank you very much, Madam Chair. Thank you.
Questions goes to MP Massey. You have 2.5 minutes.
Thank you, Madam Chair. I mentioned the Investment Canada Act, the foreign takeovers of Canadian iconic companies, Rona, most recently by Lowe's, leaving us with a false competition basically nationally between Lowe's and Home Depot, which is a joke. And then on top of that, we've had in the past, the Future Shop was sold to Best Buy. That's resulted in a loss of competition, no doubt, in the electronics industry, especially when you look at some of where other electronic industries are owned. And then another good example is the loss of Zellers to Target. With that foreign takeover, we saw Zellers, which actually paid above industry average wages, had benefits, and also had a profit. Does the Competition Bureau provide insight on Investment Canada Act when takeovers are actually brought forth in terms of commentary for the minister? Is that something that takes place?
Madam Chair, thank you. I'm back, and hopefully this microphone is working for everyone, including the translator. It's amazing how many microphones we have in this building. What I can say is that obviously the Investment Canada Act, and there's a team at Innovation, Science, and Economic Development that deals with those foreign investment issues. The Bureau examines these situations through our merger review lens, which is set out in the Competition Act.
Have any of those, in your opinion, benefited Canadian consumers? Those three episodes that I just mentioned in terms of takeovers. Now we can look in the rearview mirror. Have Canadians benefited from those takeovers and closure of competitors?
That's not something that I can comment on at this time. I haven't sort of specifically gone and looked back on those particular transactions.
So if we continue, though, to allow takeovers of competitors in the same industry, especially Canadian ones where we can control, doesn't that seem like a self-defeating purpose for consumers, not having less choices? And then also the current laws that you're under require multiple competitors in the same field to actually do comparisons. Isn't that a disadvantage?
Yes, Madam Chair, as I say, these are questions perhaps more appropriately put to the individuals who deal with the Investment Canada Act.
And thank you, Madam Chair.
Thank you very much. We now turn to MP Sloan. You have the floor for 5 minutes.
Okay, thank you, Madam Chair. So I wanted to ask a question about Section 32 of the Competition Act, and that authorizes the federal court to restrict anti-competitive exercise of intellectual property rights, but only in proceedings initiated by the Attorney General of Canada. And I'm just wondering, do you think it would be a good idea to grant the Competition Bureau the power to initiate proceedings themselves under Section 32 of the Act?
Thank you, Madam Chair. Perhaps my colleague, Mr. Durocher, could address that issue at a general level.
Yeah. So intellectual property considerations come up quite often in competition law, and we have published detailed guidelines on the issue, the intellectual property enforcement guidelines, with numerous examples. Without, I can't really comment on Section 32 itself, but note that, recent examples of action we've taken where IP issues have come up have been in our litigation against the Toronto Real Estate Board, where, oftentimes we see similar issues where a company would not share data and claim to have intellectual property or an IP right in that data. Whether or not that is exclusionary or not it depends on the facts and circumstances of a given matter. But our competition tribunal has opined on these issues, which really informs our enforcement approach that we've tried to clarify through our guidelines.
Now, I'm just wondering why you can't comment on Section 32. I mean, it seems that, my basic question of whether or not the Competition Bureau should have the power to initiate proceedings, I mean, isn't that a question that you could have an opinion on?
Well, I would say, sir, that certainly it's not something that I've turned my mind to of late. I'd be happy to provide the committee with a more fulsome answer in writing after today's hearing.
Okay. So given that, would you have an opinion on the advantages and disadvantages of allowing private parties to initiate a similar proceeding under Section 32 of the Act?
I think that would be the same answer, sir.
Okay, thank you for that. I just want to switch over to talk about internet here, and I'm just, there's been a lot of concerns about anti-competitive practices that are being engaged in by, the big internet service providers. For example, delaying or avoiding payment of wholesale access rates set by the CRTC. Is there any way that the Competition Bureau can ensure that these incumbent telecommunication service providers do not engage in any competitive practices against the smaller ISPs? If you can make any further comments on that, I'd appreciate it.
Yes, Madam Chair. Actually, my colleague, Ms. Wright, would be well placed to address this particular telecom issue.
Thank you for the question. Madam Chair, there are a number of different aspects to the telecommunications regime in Canada, and there are areas where the Competition Bureau can be involved. So the CRTC is the organization that oversees the wholesale regime in Canada. And so questions regarding that regime would be best placed with the CRTC. What I can say is that the Competition Bureau recognizes the importance of ensuring that that wholesale regime allows competition in the marketplace. And so we've been very active with the CRTC in providing our views. Most recently, we have spoken with the CRTC, provided a submission in their recent proceeding on rate setting. And there we were looking at the different ways that rates can be set in the wholesale regime and what the impact on competition would be with those different rate setting methodologies.
So just to follow up on that, it sounds like your opinion is that the Competition Bureau does not have any sort of direct ability to enforce anti-competitive practices in that sphere. It's more a CRTC regulatory jurisdiction. Is that what you're saying?
We do have the ability to take action when there is potential abuse of dominance happening, exclusionary conduct happening in the marketplace. There's a very specific test that we need to use in order to use our abuse of dominance provisions. And it also includes a requirement to show that there's been an adverse effect on competition. And so we try to take a multi-pronged approach to these issues where we have our enforcement abilities under the Competition Act, as well as our work with the CRTC to look at the whole framework.
Okay, thank you.
Thank you very much. And Mr. Boswell, if you can make sure that the information that was requested by MP Sloan gets sent to the clerk, he'll make sure to circulate it amongst all of the members. Thank you. We now go to MP Lambropoulos. You have the floor for 5 minutes.
Merci beaucoup.
Thank you very much. I would like to thank the witnesses for being here with us. My first question, you mentioned in your testimony that worldwide trade can help us to recover after COVID. What do you think will help us with this recovery? What kind of advice would you have?
As I alluded to in the opening remarks, we believe that competition, a focus on competition in Canada will assist in the economic recovery. Competition has multiple different benefits. Of course, competition drives lower prices for consumers, so affordability, more choice, and better quality products. But in terms of the macro picture, competition drives productivity increases and drives innovation. There's been a longstanding productivity lag in Canada, and if we can increase productivity, increase GDP, that will assist in the economic recovery.
Merci beaucoup.
Thank you very much. I agree with you. There will be a need.
Really encouraging productivity and that we're encouraging people, jobs being created. However, in regular times, and this is not a COVID related question, but in regular times, I've had many companies in my riding, which is a very industrial riding, come to me and complain that, they don't feel like they have equal opportunities with regards to bigger players, bigger global players. And I was wondering if there's anything in the Act that protects Canadian companies or gives them some kind of an advantage with regards to this type of competition.
Madam Chair, I'm interpreting the question as whether there's anything in the Act that helps Canadian companies compete versus large global players. There isn't anything specifically in the Act in that regard. What there is in the Act is that there's the ability of the Bureau to bring enforcement action if we discover, if the evidence shows that large global players are behaving in an anti-competitive manner inside Canada. And that is the subject of much of our work here at the Bureau, which is, we rely on complaints, we rely on our marketplace intelligence to see if there's anti-competitive conduct by big players, and then to pursue that investigation to obtain the evidence that we believe is necessary and determine if we should bring a case.
Thank you. And with regards to enforcing competition rules on big companies, we've heard a lot from telecom companies recently, and we know the case is the same for companies like Google and Amazon. Does the Competition Bureau have enough resources and legal powers to effectively enforce competition rules? And why is Europe more effective than Canada in doing so?
Thank you for the question, Madam Chair. What I can say is that, as I've said, I think several times, we're focused on doing as much as we can with the resources we have, and I'm proud of the Bureau's track record. We have a wide mandate in terms of enforcement, and we bring a lot of enforcement actions. We have done so for many years. Obviously, more resources in a more complex environment would be extremely helpful. The world is very complex for these types of digital investigations. You need special skill sets. You need data scientists, data analysts. You need to really understand what's going on under the covers, the opacity of the digital economy with algorithms and those things. So those are issues and challenges that we're tackling every single day.
My internet connection got unstable at one point, so I'm not sure how much time I have left. And I also don't know if you answered my next question, but my next question is really, what is the difference between Europe and Canada that makes it easier in Canada to actually enforce these rules?
It's quite a lengthy answer. There's certainly a different regime in the European Union with respect to competition that allows for initial prosecutions or findings of wrongdoing much in a different manner than Canada. And of course, there is much more emphasis on competition in Europe. There's the European Commission Director General of Competition for the whole European Union, and then each state. Sorry.
Unfortunately, we are out of time. So I'm going to start the next round of questions, and we go to MP Cumming. You have the floor for 5 minutes.
Great, thank you. Thank you, Madam Chair. I want to follow up on a question that you didn't get a chance to answer from my colleague, Mr. General. The relationship between the Competition Bureau, and he was on the path with distillers, hand sanitizers, just this flood into the market of product priced all over the place, effectiveness probably all over the place. How closely do you work with Health Canada on some of these issues?
Yes, Madam Chair. Thanks to the honourable member for that question, for following up. I did want to respond to Mr. Generu that, in fact, the Bureau has been working quite closely with Health Canada throughout the pandemic. And our emphasis in that work has been on what I talked about earlier, which are false or misleading representations of products that prevent, treat, or cure COVID. That's been our focus. We've been in touch with Health Canada. We already have an established relationship with Health Canada on other enforcement matters, so we're able to build upon that. I also should point out that we created a specific portal on our website that also connects Canadians, not just to the competition issues, but connects them through to Health Canada and the Public Health Agency of Canada, as these issues are all intertwined.
I want to come back to discussion, and I'm finding this very informative, and thank you for being here today. Related to the large tech players, the dominant players, and particularly the giants, where we're seeing organizations like Amazon, particularly coming into the market, and the use of data. And I know that you said you will be reviewing C11. But it strikes me, with that kind of dominance and that control and use of data, should we be concerned that there's not enough teeth within your act or within C11 to deal with things like customer lists, like stuff that's proprietary that could really put smaller Canadian companies at risk. These small businesses that are using a service provider, what they think is a service provider, but actually could quite rightly be a competitor.
Well, I'm not too familiar in terms of the connection to C11 in that regard. But what I can tell you is that it's very clear that with these large platforms, data is uh, is a huge factor in controlling the market. If you control the data, and it's very difficult for entrants to come in to acquire the necessary data to have the scope and the scale to compete. Those are very significant issues in terms of competitive intensity, new entrants coming into a market. So we're paying very close attention to the competition issues related to the control of data, preventing access to data, which is why I did point out earlier that the data mobility provision in C11 is certainly interesting. It ties to something that the Bureau has been talking about for some time, which is data portability, which ties into things like open banking that could provide more competition in the Canadian marketplace. So I'm not sure if I answered Mr. Cummings' question. I hope
It was close enough. It was headed in the right direction. So given the change in the marketplace, and it's significant change, and for your department, and my colleague also talked about your budget, and trust me, I'm never one to spend more money at the nature of how I run my budget. But have you got adequate resources to be able to deal with the new digital age and some of the things that are in front of you, and the talent on your team to be able to deal with what has really changed the entire competitive marketplace?
Yes, Madam Chair. Thank you. I see the warning sign, so I'll be as succinct as I can be. These are pressing issues for the Bureau. We are working as hard as we can to do the most we can with what we have, but the world is incredibly complex in terms of competition law enforcement, getting more and more complex and more demanding every day. We literally have mountains of electronic records to deal with on cases, and so those are the challenges we're facing.
Thank you.
Thank you very much. We'll now go to MP Assassi. You have the floor for 5 minutes.
Thank you very much, Madam Chair. Mr. Boswell, again, if we could return to the first issue that was raised, which was you said that your Bureau is following developments in other jurisdictions around the world in terms of dealing with the big dominant grocers in the Canadian market. First of all, insofar as the Competition Act is concerned, what would your recommendations be? And as you can imagine, during difficult periods such as this, a lot of Canadians are very much concerned about these practices. So would you be good enough to not only provide suggestions as to how the Competition Act can be improved, but also if there are any other remedies other than the fact that the federal and provincial governments work on this together that we could look to in terms of federal legislation. Thank you.
I think, Madam Chair, I thank the honourable member for that question. I think an interesting aspect of this when one looks at the international landscape and specifically to the United Kingdom. The United Kingdom's code of conduct in terms of grocery supplier relationship developed as a result of an in-depth market study undertaken by our counterparts in the United Kingdom, the Competition and Markets Authority, the UK competition enforcer. And they have a market study power that allows them to really examine if a market is working in terms of competition by compelling compelling information from market participants, analyzing that information, and then providing evidence-based recommendations to their government. In Canada, we conduct market studies, as you've heard about today, but we don't have the market study power to compel information and to provide recommendations to government. And just to go back to the United Kingdom, that's how their code of conduct came to be, and it's been well received because it was based on evidence.
Thank you for that. Now, if I could switch to a very, very different topic. You recently appeared before the Canadian Club in Toronto, and one of the issues you highlighted for attention was the need for the Bureau to have better powers to ensure that we are fostering competition in the digital space. Are there we had an opportunity to highlight some of the changes that have been made. Are there any other recommendations that you would like to share with the members of this committee?
Thank you, Madam Chair, and thank the honourable member for the question. What I can say is, as I've said, back in May 2019, Minister Baines, in an open letter to me, asked our team here at the Bureau to work with his team at ISED to make sure the Competition Act was fit for purpose in terms of tools, the legal framework, resources, all those issues. We've been working with Minister Baines' team, and since that letter was received, and we're continuing to work with them in terms of going forward.
Thank you for that. Now, if we could go back to an earlier response that you provided, I think it was to Mr.
MP
Dreeshen.
Sassy, my apologies. Could you just move your microphone a little bit further away from your mouth? I'm getting a popping sound, so I'm assuming translation is as well. Thank you.
My apologies for that. Mr. Boswell, just going back to a question that was posed to you earlier by Mr. Dreeshen, you talked about the global competition review. Assessing the resources and the toolkits that the Competition Bureau has vis-a-vis other authorities around the world, how are we doing as a country, and how is the Competition Bureau doing in the grand pecking order of things, if you will?
Madam Chair, what I can say is that our assessment from inside the Bureau, and we work with our partners all around the world. We work very closely with our Five Eyes partners, our European partners, and many others. Our assessment is that Canada's Competition Enforcement Agency, and I should point out, we are it for Canada. There are no provincial competition enforcement agencies, unlike in the United States, where each state has an attorney general that deals with competition. And of course, as I said, Europe has the European Commission, and plus every European member state has competition powers. It's likely that we're one of the least funded competition enforcement agencies, certainly in amongst our peers.
And in terms of resources, you've alluded to that on several occasions, especially cutbacks that happened approximately a decade ago, as I understand. But in terms of performance, how are we viewed around the world?
Well, Madam Chair, I'll try and be objective, because obviously I'm extremely proud of the Competition Bureau and the amazing people that work here. But the number of times I've heard from colleagues around the world, including colleagues at the OECD Competition Committee and the International Competition Network, how the expression that repeatedly is said is, in terms of international convergence and working together, the Competition Bureau routinely punches above its weight. That's the expression I hear over and over and over from colleagues around the world. So, as I say, we are working as hard as we can to serve the public interest with the resources we have.
Thank you very much for answering those questions, and thank you for the great work you're doing at the Competition Bureau.
Thank you.
Merci beaucoup. Donc, le prochain tour.
Thank you very much. The next turn is 2.5 minutes for Mr. Lemire. Thank you very much. And thank you for the colleagues for the questions that have been asked today. I do appreciate it. I would like to ask you about private-public partnerships in the internet concept. In my region, in Temiskaming, we don't have a lot of population. It's not very dense. And so it's very difficult to be able to connect. We're amongst the 2% left to be connected. And when I was told that there was the tribunal, the Competition Bureau, was independent, and so I would like to give you this information, so you should be looking at this issue. I would like to ask you a question with respect to your analysis of the Air Canada transaction. The research has been done on that. Do you consider an update on with respect to airline transport and regional transport? Is it possible that the negative effects of the pandemic would justify the absence of a competitor in the market, because the pandemic is temporary, but the air transit activities may be permanently affected?
Chair, perhaps I'll start, and my colleague, Mr. Durocher, can supplement. Just in terms of Mr. Lemire's question, in terms of Air Canada's proposed acquisition of Air Transat, that's a situation where the Canada Transportation Act allows the Minister of Transport to make a decision that there'll be a public interest review of that matter. That decision was taken. And when that decision takes place, in terms of transportation undertakings, my role is to provide information to the Minister of Transport with respect to the transaction, more specifically, any concerns regarding potential prevention or lessening of competition that may occur as a result of the transaction. That input was provided back in March 27th, 2020. At the time, we took note of the pandemic in the March 27th report we provided to the minister. This matter is continuing, so I can't comment further, as the next stage is to provide information to the minister on proposed undertakings by the parties to resolve competition concerns.
With respect to lack of help for small company air transport companies, for this issue with Air Canada and Transat, do you think there can be an action that where there's a monopoly because of a government position? In such situation, that implies federal government decisions, what we can do is offer our advice to promote policies, government policies, that would favor competition. Thank you very much.
You have the floor for 2.5 minutes.
Thank you, Madam Chair. Back in 2003, the then Competition Commissioner came to this committee and said that they didn't have the proper supports necessary to investigate price gouging in the gasoline industry. From that, we had hearings from 2003 to 2005, had a report that was commissioned, and eventually a petroleum monitoring agency was announced in the dying days of the Paul Martin government. And then after that, it wasn't funded by the following Harper administration. My question to you today is, nothing's changed in that scenario. Do you have enough powers to successfully investigate potential price gouging for the petroleum industry, especially when it comes to retail and then upstream and downstream investigations? In the United States, they have some more robust laws with regards to disclosing market purchasing. Would that not protect Canadian consumers a little bit better than their current situation?
Thank you, Madam Chair. Thanks for the question, Mr. Mass. The Bureau does not have specific price gouging powers, and that issue has come to light once again during the pandemic, as there have been complaints of different types of price gouging related to products that people were looking to buy on an urgent basis in terms of the pandemic. The power we do have, as you know, sir, from your work in this area, is to investigate and refer for prosecution gas price fixing cases, retail gas price fixing cases. We've done so. We had a significant gas price fixing case in the province of Quebec, where 3 separate rounds of charges were laid in 2008, 10, and 12. Over 20 convictions of individuals, multiple companies convicted, millions of dollars in fines. We also had a gas price fixing case in Ontario. So that's where we're able to take action in terms of retail gas, is where we find the evidence of agreements between gas stations to fix the price.
If the laws were modernized, would you feel confident that the Competition Bureau could do more work to protect Canadians on gas price fixing and that issue if the laws were updated?
I guess it would depend, Madam Chair, on what aspect of the law was updated. These are often tricky investigations that involve wiretaps, search warrants, and getting to the truth.
So again, it's back to resources, and what we pay for is what we get. Thank you, Madam Chair.
Thank you very much. Our next round goes to MP Dreeshen. You have the floor for 5 minutes.
Thank you very much, Madam Chair. And it sounds like if 2008 and 10 and 12, there was some action taken with regards to price fixing that seemed to be working at that particular point in time. And I guess we wanted to take a look at exactly how the petroleum prices are. We could talk to former Liberal Dan McTeague, who could easily tell folks just what we can expect as far as prices are concerned. But what I'd like to go back to, and I alluded to it earlier with the global competition review, and just listening to the testimony that you had, Mr. Boswell, when we talk about transportation, and as soon as it looked as though there was some kind of an issue, I believe it was Air Transat and I believe Air Canada. So once it gets to that stage where there's a lessening of competition, you would anticipate if that's in the public interest to review it. I'm just curious at how robust the government is in taking the advice that you have, and I'll tie that into another point in a moment.
I'm not, Madam Chair, I'm not in a position to comment on how much they take into account my advice. My role is to provide that advice. Did so on March 27th, 2020, in an extensive report that set out extensive competition concerns about the Air Canada acquisition of Air Transat.
Thank you. Now, my reason for asking that is on transportation, you got to a stage where they were going to pay attention to what you were saying. When we talk about the Investment Canada Act and we see foreign actors that are coming in to pick up distressed companies, really then as far as competition is concerned, once that's done, the only time you have a chance to comment on it is once we start to see negative effects from the fact that these companies have come into Canada and are starting to change the landscape, so to speak. Similarly, companies like Amazon and so on, you don't really know what they're going to do. It all sounds great to have them here until you start to see how it affects other companies as far as competition is concerned. So how do you keep up to that? How do you keep up to Investment Canada decisions that allow companies to come in that can then do what they please, and then you're there to clean up the mess? And the same thing happens with some of these other companies that are coming in and start to displace Canadian companies.
Well, Madam Chair, we go about our work in the parameters that are set out by the Act and set out by case law in Canada. We review mergers to determine if they're going to result in a substantial lessening or prevention of competition in Canada. That's our focus when there's acquisitions. We do the work when it's a foreign competitor coming in seeking to buy a Canadian competitor. We will do the analysis to determine if that's going to result in a substantial lessening or prevention of competition in Canada. And we are vigilant for other foreign companies that are operating in Canada to make sure they're not engaging in anti-competitive conduct, to make sure they're not engaging in false or misleading representations. So we're paying attention to the greatest extent we can on these issues.
And that takes me back then to what you had talked about with our Five Eyes partners. We have a situation where, of course, Huawei has been certainly in the news. We've seen what all of the other Five Eyes partners have talked about, where they're going, and would concerns about Huawei ever come to you prior to any decisions being made by the government, or again, does that simply come in after the decisions have been made?
Those issues are certainly beyond my mandate as Commissioner of Competition.
Okay, thank you. And I know I'm getting down on time, but I just wanted to make this one final point. When we talk about competition, we look, and with COVID, we've seen small businesses in communities being shut down, and yet box stores have been able to stay open. This is, again, one of those competition situations. I don't know whether or not you have any comments on that.
I think it would be inappropriate for me to comment. These are public health considerations that I don't have the foundation to make an appropriate comment on.
Okay, thank you very much.
Thank you very much. And our last round of questions goes to MP Erskine Smith.
Thanks, Madam Chair. I first want to start, Anthony, you probably recall when you attended before our privacy committee and we had a conversation about data portability, and it hadn't been in the competition commissioner's early reports, but I know that you have taken data and privacy issues much more seriously now, and I think as a consequence of that, we now see it in C11. So I just want to thank your office for that. When it comes to the Facebook agreement, which I think is also good news, that consent agreement and a $9 million fine with $500,000 also to reimburse the commissioner for costs. When we look at the states and the fine of $5 billion, I mean, even when you adjust for population here in Canada, it would still be significantly more in terms of a fine in the United States than we saw in Canada. Can you speak to the capacity of the competition commissioner to levy those fines and why it was 1/5 of what we saw when you adjust for population?
Yes, Madam Chair, I'll start. The Act has a maximum financial penalty for false or misleading representations, which was the section of the Act that we were investigating Facebook for. The maximum is $10 million. As a matter of general course, we'll give a slight discount for parties that cooperate and resolve the case. That's why we ended at 9 million, but the max is 10 million. Should point out that the U.S. Financial penalty was, in fact, as you say, $5 billion. There were some differences. There had been a prior consent order in the United States in 2012 involving Facebook, and there were other privacy issues, as the Federal Trade Commission in the United States also has privacy within its remit. But the fact remains that our max fine is 10 million.
When we look to cooperation with an organization like the FTC or competition commissioners in other countries, can you speak to the agreements that you've entered into, if any, as it relates to enforcing rules against some of these global players?
I wouldn't say, Madam Chair, I wouldn't say to answer the honourable member's question that we have agreements with respect to enforcement. We work together, we collaborate on enforcement, we communicate on enforcement, but there aren't specific agreements, to put it that way. And our enforcement cooperation is one of the most important things we do in terms of global cases. We see that in our cartel work, where there are international cartels. We prosecuted a series of them for auto parts bid rigging and price fixing, and we had to cooperate with authorities around the world as they were, these companies were under investigation around the world. We do that with the FTC, with the United States Department of Justice, with Australia. It's vital that we do this kind of cooperation.
When we look to cooperation with our American allies, I remember when your office hosted, in fact, a conversation with experts on competition concerns in big data and privacy companies that are involved in big data markets. When you look to, I don't know if you've had the opportunity to read the our American colleagues subcommittee on antitrust, commercial and administrative law of the Committee on the Judiciary investigation of competition in digital markets. It's a big report. It's 450 pages. But I wonder if your office has started a review of that and would be making recommendations to Canadian parliamentarians about what changes you might like to see along the same lines.
Yes, Madam Chair, we're certainly familiar with the report from the U.S. House Antitrust Subcommittee, Representative Cicilline leading that work, but also, a lot of bipartisan support in the United States for more antitrust or competition law enforcement, bipartisan support for more resources for their competition agencies in the United States. So it is, as Mr. Erskine Smith mentions, it's a significant report. It's 450 pages, but there's bipartisan support for more enforcement of competition laws in the United States.
And if you do have a review and you can provide that at some point to our committee, it would be appreciated when it comes to recommendations. And my last question is simple because I'm running out of time, yes or no. Does the Competition Bureau support a right to repair?
That's a good question. Mr. Durocher, do you have, can you answer that?
One thing we'd be happy to share with the committee is we did make a submission last year to the Quebec government in respect of right to repair issues, and I think that we would be pleased to share that with the committee members.
And the answer there was yes. I appreciate it. Thanks very much.
Thank you so much. And that is our time today. I want to thank the witnesses for being here for a really great panel today. And of course, for the work that you're doing. I think it's fair to say that you're punching above your weight, as you mentioned. So thank you so much. Je veux aussi remercier.
I would also like the translation services for the hard work that they did.
One moment, Mr. Massey. Je veux juste remercier le...
Just a moment, Mr. Massey. I just simply wanted to thank you, Interpretation Services. Go ahead, Mr. Massey.
Oh, I'm sorry to intervene. I just wanted, there's two quick things. Could we get a list from the analysts of outstanding questions that we're going to get back? I know the Competition Bureau will get back to us, but there's a few other witnesses that have yet to get back to us. Maybe perhaps we could get an inventory of those outstanding answers that we have. And also thank Mr. Dreeshen for mentioning former member of Dan McTagg, who is the author of that legislation in the House of Commons, and also the committee work here too as well. So there's lots to look at there. Dan was the one who pushed this issue so well. Thank you.
Thank you so much. Well, while not a point of order, I will ask the analyst and the clerk to prepare a list of outstanding questions. Thank you so much. And with that, I'd like to say meeting adjourned, and I will see you all next Tuesday. Thank you.